Because we're just getting word that the hearing for Lori Vallow has begun, Lori Daybell, and so we're going to go to that right now.
Inmate Legal Services works. Did you receive the state's response yet?
I did receive it yesterday, but I was hoping that I could put my response on the record today, my reply.
That's fine. Go ahead.
Ready?
Yeah.
Okay. Oh, let me get my glasses. Do you want me to stand, Your Honor, or can I just sit here?
You can sit there.
So the state has claimed in their response that these documents are not material in the case, and this defense is entitled to this specific evidence for the proposition that this evidence can be used to impeach the thoroughness and good faith of the police investigation and the intent of the prosecution. That's Kiles versus Whitley, 514 U.S. The acid test of this prosecution is not a matter of determining if the defendant is guilty of the crimes that the defendant is charged, but rather, was any crime even committed? And where is this evidence? This defense has yet to find any evidence of a conspiracy in the 100,939 pages that have been turned over by the state. The state does not get to say, like they did in their last motion to us, in their last answer, to say, oh, we gave you over 100,000 pages, so that ought to keep you busy. That's not how it works. These are serious charges, and these are serious consequences for these charges. In determining the actuality of a crime, the state is required to meet, in reality, not in theory, a standard of culpability that is defined by law as a crime. The state is required to meet the challenge of defense reasonably without bias, conflict, prejudice, or speculation. So the defense, we keep filing motions for discovery since we don't know if it's some kind of strategy of the state that they're holding back this actual evidence of conspiracy in hopes that the defendant won't have time to prepare a proper defense against the evidence that comes forward at the last minute. This court has denied every motion the defense has filed to acquire this evidence. The state has claimed in their response to the defense's motion that the defense's request is overbroad and wide-sweeping. Is this the defense left to pinpoint where this evidence is and try to find it? No, that is not the law. The state is required by law to give the defense evidence of the crime they are being charged with. This is the purpose of the Brady Law and the right to due process. This is why in 2020 the United States enacted the Due Process Protection Act that provides defendants like me with greater protection, Brady versus Maryland. The state has continued to impede the defense from conducting a defense. This is a violation of the 14th Amendment of our great Constitution and the defense's due process rights. Today, the defense is requesting that this court do the following three things. One, order the state to turn over all evidence of a conspiracy since our trial begins in 76 days from today. I would also ask that they would pare down their witness list to these witnesses that will actually be testifying so the defense can conduct productive interviews. And then I would like for all motions and responses to be sent directly to the defendant in a timely manner. I'm having a really hard time getting this stuff. I don't get it from ILS to 7 days after things have been filed, after your orders have been rendered. I'm not getting these. This defense intends on starting trial on time without delay, and I request that also that this defense requests that the court grant the motion to order the state to produce all discovery of extradition at this time so that we can get started on getting prepared for trial.
What does anything in the extradition have to do with the underlying charges? Can you tell me that?
Yeah, it's to find out why all this started when I can't find any evidence that there is. So,
have you read the grand jury transcripts?
I have.
Okay. The grand jury transcripts summarize what the state's evidence they intend to produce at trial.
I understand that.
So when you say you can't find anything, that is the summary in the grand jury transcripts?
Correct.
Okay. So I guess I don't understand how an extradition a year or so after the fact, after the indictments, would have anything to do with the underlying charges. So can you articulate that for me?
I can, Your Honor. There's the detectives that are on these cases are all continuing to go back and forth with all of these different agencies. You have the FBI, you have all the different agencies that are working together. You have Rexburg, Fremont County, you have Chandler and Gilbert. You have all these people. Then I have them coming up, and they're going to be on the stand, and they're going to be in trial, and they're going to be saying what they reviewed. They've reviewed all these things, and there's communications between all of these agencies that I feel like that the defense is privy to. We should be able to have that and look at that and see where all this came from, where all this started, why they waited 2 years to make these charges. There's all these things, and why they decided to extradite when I saw someone sent me a news article 3 days before I got brought to Arizona that MCAO was putting out a release that they were not going to pick me up and they were not going to extradite me to Arizona until after my appeals were finished. So it's contradictory to that. I just don't know where it came from, and there's a lot of things that are mystery questions to the defense that we are entitled to according to the law.
All right, well, everything you've just told me, none of that would be relevant in the trial in the case in chief. Does the state intend on producing any iota of evidence or presenting any scintilla of evidence of anything that happened after the dates of crime that have been charged in the indictments?
Well, the state, although there is information that occurred after that will relate to the conspiracy that has been disclosed to the defense, anything that occurred after the indictment, during the extradition process is completely irrelevant and will not be brought in during the trial.
I didn't mean the date of crime listed in the indictment. I meant the date of the indictment. Correct. So the state doesn't plan on presenting any evidence to a jury of anything after the indictment.
Correct.
So how would that, anything to do with the extradition, be relevant to your trial then?
I feel like it's relevant to the whole, Your Honor, in the sense that the police investigation and the intent of the prosecution, it doesn't make sense. I would like to be able to have that.
All right. Are you otherwise on track for your trial date?
Correct.
Are there interviews going on with your investigator or your advisory council team?
We're working on getting those set up right now.
Okay. Is there anything else we need to address today? This was sort of just a status conference to make sure things are on track.
I have 2 motions that I'd like to file with the court today.
All right. Do you have copies for the state?
I don't today. I thought you could make a copy.
Can we see them?
Sure.
I'll ask the deputy county attorney, from your perspective, anything we need to discuss here today? Yeah.
As Lori Daybell gets those motions, all that paperwork together for the judge to see, we are going to squeeze in a quick break, but we are going to have more from the Lori Daybell hearing in the Cult Mom conspiracy case in Arizona. We'll be right back.
I'm Vinny Politan. Welcome to Closing Arguments.
What's happening here?
It's unreal. Let me show you exactly what happened.
Closing Arguments with Vinny Politan, tonight at 8/7 Central, only on Court TV.
JonBenet is God.
Part 2 of a special report.
Exclusive video of the man who claims to be JonBenet Ramsey's killer.
Vinny Politan investigates, tonight, 9/8 Central, only on Court TV.
Case that the state intends to try first?
Correct.
How long would that case take for the state's portion to present?
Probably a couple weeks, Your Honor. I mean, and I say that obviously I'm unaware of how long defense will take for cross-examination. So I would probably ask to pre-screen the jury for significantly longer than that.
Meaning 3 weeks or 4 weeks?
Yes, Your Honor. I obviously do not know what Ms. Daybell is going to question any of the witnesses.
As we're looking toward that trial date, is advisory council willing to assist the defendant on the jury screening process if we do the electronic questionnaire?
Yeah, so that, yeah. to the
Okay.
extent that we-
All right, good.
Going outside of our scope, but yes.
Sure. I have received a motion for specific discovery from the defendant, well, two separate ones. Just going forward, can you title them maybe what specifically you're looking for? Because if you name all your motions the same thing, it gets a little difficult to keep track of them. But I have two separate motions for specific discovery.
Just like Discovery 911 call.
For example, on this one, you could title it something like motion for discovery related to the Gilbert DR number or something like that, just to differentiate these. We'll make copies of these for the prosecutor, and then we'll have those filed with the clerk today. One of your requests was to have the state send you directly any pleadings, which according to their mailing certificate at the back of the pleadings, they are mailing them to you. I can't do anything about how long the jail takes to process that. So I do recognize that there's probably some delays on that, so we won't hold you to the normal reply times because of those delays that it takes getting through the jail administratively. All right.
In that case, Your Honor, could we have perhaps that go to my investigator, then I could maybe get those faster? Can he also be included on that?
Your Honor, I do email them to advisory council as well as in the court, so
All right.
but there's not much else I can do.
Who's your investigator?
Jeff White.
And your advisory counselor in contact with him? Yeah.
They can be.
Okay. So the record will reflect that the state's getting a copy of those two motions today, and then the state will respond accordingly. I'll just set a I'll have you reply within 10 days of the date of the filing of their response. All right. Depending on and then I'll rule on the motions as they come, or I'll set a hearing if need be. But at this time, I'm going to affirm the final trial management conference of March 18 at 8:30 a.m. in this division. Trial date's currently March 31. Again, the first case that would be heading to trial would be the 2021 case. Anything else for today?
Yes. Will trial be staying before Your Honor? And if so, will we be staying in this courtroom?
I don't know yet. I'm going to confer with the associate presiding judge, and I suspect it will stay here and it will stay in this courtroom, although for jury selection, we may move to a bigger courtroom if we're doing in-person voir dire.
And Judge, I do know there will likely be the next of kin present. This courtroom obviously does not have a victim room or a witness room. With the media, that obviously makes it more difficult for the state to keep those individuals away from each other, from overhearing each other in this type of case. So obviously, we're happy to stay before this court, but would be requesting that this be reset or moved to the South Court Tower so we would have those accommodations.
I'll talk to the criminal presiding judge and the associate presiding judge regarding that, and it's just a matter of availability of bigger courtrooms. Anything else from the defendant?
I just was going to ask, can we set both trial dates, or how are we going to do that?
You'll have two separate jury trials with two separate juries.
Correct.
So the first trial that will be on or around March 31st. We anticipate when that trial's done, we'll talk about how quickly we're going to do the second trial. Does that answer your question?
Somewhat, yes.
Okay. It's hard to set the second one without knowing how long the first one's going to take, and then the readiness of everyone as far as the second one after the first one concludes. All right, we will be at recess on that matter. I'll take any motions under advisement.
Okay, that hearing has concluded in Arizona. This is Lori's first hearing since the judge approved her request to represent herself. As we continue to watch what unfolds there in the courtroom in Arizona.